2014-153, 2010-33. State of Arkansas versus Bradley Taylor. Mr. Taylor, you're appearing at this time for purposes of changing your plea, both in the case 2014-153, which is a new set of charges, and also on the revocation proceeding that's pending against you.
It's my understanding the revocation is going to be null pros, Your Honor.
Judge, we're just going to off and let the revocation run concurrently throughout the court.
All right.
He feels that.
That's correct.
So just continue him on probation
Yes,
on
sir.
that?
Yes, sir.
All right, so it's just the petition to revoke that's being dismissed. All
That's
right.
correct, Your Honor.
All right. On case 2014-153, you're charged with possession of controlled substance methamphetamine, which is a Class D felony, and use or possession with intent to use drug paraphernalia, which is a Class D felony. Is that correct, Mr. Taylor?
Yes, sir.
And on those charges, how do you now plead?
Guilty.
You're entering this plea of guilty pursuant to an agreement. Is that correct?
Yes, sir.
And the agreement's been worked out for you by your attorney, Mr. Downham. And have you discussed it with Mr. Downham and understand the terms and conditions of the probation?
Yes, sir, I have.
Or of the plea, excuse me. In this case, you're entering a plea on these charges. Part of the agreement is the state will move to null pros 2 other charges that you have pending against you. And another part of the plea is that you will be entering into probation, and as a condition of probation, that you will be entering into the drug court program. Is that right?
Yes, sir.
Okay. You heard well, you know, you wouldn't have, you weren't in here to hear it, but I don't want anybody to go into the drug court program without understanding clearly what, in other words, I want you to have your eyes open about what it's all about. The drug court program, if you don't understand it already, is a program to assist you in dealing with issues of drug use and drug addiction in your life. It has some benefits that might be the motivation to enter this plea. That is, you don't get sent to the penitentiary. You have the opportunity on down the road to have your record sealed. But the real object of this program is to assist you in addressing issues of drug addiction in your life. That's what the program's all about. And with that in mind, I want people to understand that this isn't like just any ordinary probation. If you enter this program, you're not only going to be on standard probation, but you're going to be under very close supervision of probation. You're going to be required to do a lot of things, take classes, attend various meetings, participate in a variety of activities, all designed to address the issues of drugs in your life. And it will go on under the best of circumstances more than 2 years. Now, there have been people who it took 5 years to complete the program. And kind of once you get in it, you can't get out of it other than going to the penitentiary. So, I mean, you need to be committed to addressing those issues in your life and trying to change your life and the way you live it. And if you're not, then this may not be the program for you. And so that's why I always want to start out by saying you need to understand these things about the program. Is once you commit to it, you're in it until you complete it.
Okay.
You understand that?
Yes, sir, I do.
All right. And are you willing to undertake that?
Yes, sir, I am.
Very good. I welcome you to the program then. All right. Then let's go back to taking the plea on this matter. You've indicated you're entering a plea of guilty on the charges of possession of controlled substance methamphetamine, a Class D felony, and use or possession with intent to use drug paraphernalia, a separate Class D felony. The agreement involved here is set out in writing in this document I'm holding up called a plea statement. Have you read through this
Yes, sir, I have.
plea statement, signed it,
Yes, sir, I have.
and do you understand what's set out in it?
Yes, sir, I have.
Have you also had an opportunity to meet with the drug court personnel and go over the drug court handbook and
Yes.
it sets out the rules and the requirements?
Yes, sir.
All right. You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you're giving up or surrendering by pleading guilty?
Yes, Your Honor, I do.
When you plead guilty, you're giving up really basic constitutional rights, such as the right to a trial by jury, the right to be represented by an attorney and have the assistance of that attorney at trial. You're giving up the right to confront the witnesses that would appear and testify against you at trial, and you're giving up the right to appeal. All of those are rights you're giving up in order to plead guilty here today. Do you understand that?
Yes, sir.
And has anybody, are you entering this plea of guilty freely and voluntarily?
Yes, sir, I am.
Has anybody in any form or fashion forced you into entering that plea of guilty?
No, sir.
As you plead guilty, do you acknowledge the truth of the accusations against you?
Yes, sir, I do.
You acknowledge that on or about the 4th day of June 2014 here in Baxter County in Mountain Home, that you had in your possession a quantity of methamphetamine?
Yes, sir.
And you also acknowledge that you had in your possession a quantity of drug paraphernalia associated with the use of meth?
Yes, sir.
Very good. Based on those statements, the court can find that the defendant has freely and voluntarily entered his plea of guilty, done so after consulting with an attorney, and acknowledged the facts that constitute the crime. On that basis, the court is going to find the defendant guilty of possession of controlled substance, methamphetamine, Class D felony, and use or possession with intent to use drug paraphernalia, a separate Class D felony. The court, pursuant to the agreement, is sentencing the defendant to 6 years in the Arkansas Department of Corrections on each of those counts, with those sentences to run consecutive, I'll say it again. Those sentences to run consecutive with each other for a total of 12 years, and then be suspended, subject to the standard terms and conditions of probation in this case. Those standard terms and conditions of probation are in writing and set out. A special term and condition of that probation will be the defendant will enter the drug court program and successfully complete that program, however long that may take. The court is imposing court costs in the amount of $200, a $1,000 fine, the statutory DNA fine of $250, a drug crime assessment $125, a book administration fee of $20, all of which are due and payable as a term and condition of probation, payable at a minimum rate of $100 per month beginning within 30 days of this date. The court will place the defendant into the drug court, onto probation and into the drug court program. To that end, the court has signed the written terms and conditions of probation, which are attached here. Notes the defendant has signed the acknowledgement of the terms and conditions of probation that he has read, understands, and will comply with the terms and conditions of his probation, which will include the drug court participation. In case 2010-33, the state accepts the state's recommendation to dismiss the terms and conditions of probation that he was already on. Dismiss the petition to revoke those, and at this point he'll remain on that probation with those obligations set out for payment of costs and fines and fees. And those will run concurrent with the 12-year probationary sentence the court is imposing here today.